The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good afternoon. The next case is State versus Wright, and we'll hear from the appellant.
Good afternoon. May it please the court. I'm Mary McCullers-Reese for the defendant appellant Michael Eugene Wright, and I'd like to reserve 5 minutes for rebuttal. In this case, the majority upheld Mr. Wright's conviction for felony larceny, even though the jury couldn't have determined that the value of the goods was more than $1,000 without resorting to the speculation prohibited by this court in State v. Holland. Based on the lack of evidence as to value, the dissent would have vacated the felony larceny conviction and remanded for entry of judgment as to misdemeanor larceny. Mr. Wright respectfully asked that this court embrace the reasoning of the dissent and vacate his conviction for felony larceny. Mr. Wright was indicted for taking one thing: a large propane tank that was used to provide utilities to migrant housing at a nearby farm. The tank could hold 120 gallons or 420 pounds of propane. And the state identified that one item in the indictment with reasonable certainty and by the name typically used to describe it: propane tank. The basis alleged for felony as opposed to misdemeanor larceny was the value of the tank, which was alleged to be more than $1,000. Based on that allegation, the charge was elevated from a Class 1 misdemeanor to a Class H felony. Both the majority opinion and the dissent based their discussion on that value of that one item, but they reached different results based on their reasoning as to the evidence of value presented to the jury. As to value in a felony larceny prosecution, the state must present substantial evidence that the goods in question are worth more than $1,000. It's well established that the value is the fair market value of the goods at the time of their taking, which means the reasonable selling price at the time and place and in the condition in which goods were taken. Here, the only evidence of value came from the propane manager, Mr. Spiegel, who filled and serviced the tanks. He made clear that he differentiated between the three items the prosecutor questioned him about: the tank, the regulators, and any fuel that might have been in that tank. Said he had no clue how much fuel might have been in the tank, but that a full tank of fuel would have been about $300 worth. That plus $180 for 2 regulators and some value for the tank added up to $1,330. So instead of giving the jury a value for this propane tank, he gave them a total estimate that included other things of unknown value. Subtracting out the value of the regulators, $180, and whatever amount he might have included for fuel, the jury would have been left with a value somewhere between $850 and $1,150 for the tank, and amounts evenly split above and below $1,000. And he gave them no basis for making the choice within that range. And of course, $150 in either direction from $1,000 sounds like an insignificant amount to talk about. But for Mr. Wright, that range meant the difference between serving 120 days and serving 20 to 36 months active. This court addressed the issue of value in State v. Holland in 1986. And that case involved a Chrysler Cordoba that was stolen. The state presented a photo and evidence that the owner took very good care of the car, that it was his favorite car. They kept it under a shed. And this court held that that evidence was not sufficient to submit to the jury to determine whether the Cordoba was worth more than $400, which was the value at the time. And in so saying, this court cautioned that the jury may not speculate as to value. Since Holland, the Court of Appeals has interpreted that direction, that the jury must not speculate, in different ways. State v. Parker in 2001, items stolen included VCRs, camera, photography equipment, and the estimated total value of all the missing items was $5,000. The Court of Appeals held that testimony that the total evidence, the total value of the items taken, was insufficient for the jury to determine that the items actually, items he was stolen with were valued at over $1,000. Because the total value of everything missing was not substantial evidence of the items for which the defendant had been indicted. Like the present case, the state was asking the jury to reach a value for certain items included in the indictment by giving them a total value that included both those items and others without giving them a means for separating them out.
Was there ever a point in the present case in which Mr. Spiegel said that the value of the tank was some amount over $1,000?
He never isolated the value of the tank. He offered to, and the state declined that offer and said, no, tell us everything. And he said, well, everything, fuel, regulator, tank, $1,330. He's $1,300 to $1,330. So in the light most.
So that there is some point at which the witness did say that the value of the tank was $1,330. Is that correct?
I don't know that he ever said just the tank is worth more than $1,000.
Okay. If you remove the just, is there a time that he said the value of the tank was $1,330?
Your Honor, I'm not aware that he did. I think he was combining them. He offered to isolate it, and the state said, no, give me everything.
To put Justice Morgan's question in another way, does acceptance of your client's position in this case require us to conclude that your client was charged with taking the tank but not the regulators?
Yes. Yes, Your Honor.
In other words, if we so essentially, therefore, if we accept your contention that he was not charged with taking the regulators, you win. If we don't accept it, you don't.
I don't think that's quite true. I think you would have to accept my contention that he wasn't charged with the regulators, because
I'm just trying to get beyond. You're trying to make sure I understand the ramifications of your argument. Assuming that you prevail on that assertion, then your client is entitled to relief. If you don't prevail upon that assertion, your client's not entitled to relief. In other words, the whole case hinges upon whether there is a charging taking of the tank is sufficient to include the value of the regulators.
That's true, Your Honor.
Okay, all right. That's the way what I thought, but I always like to make sure that I'm understanding the case correctly.
Based on the numbers, that's my understanding as well.
Now I'm a bit confused. I thought that you said the regulators were worth $180.
They were worth $180. I struggled with that.
So really the question is, does the taking of the propane tank include the fuel that was inside of it? Because then it's over $1,000.
I think you have to, I think you have to accept our contention as to the regulators. As to the fuel, even if you were to say, well, the fuel was actually contemplated by the indictment, which we contend that it was not, I still don't think that the state presented adequate evidence that there was any fuel in the tank at the time that it was taken.
So if there's no fuel in the tank, then you're left with $180 for the regulators, $1,330 for the package, if you will. So you're still over $1,000.
Right. That's correct, Your Honor. And I think you would have to accept, A, the regulators were not contemplated by the indictment. They were a separate entity altogether. And the fuel, whether you accept that contention as to the indictment or not, I would still contend they didn't present any evidence as to what amount of fuel was in the tank. There was no evidence there was any fuel in the tank.
Counsel, I'm looking at the dissenting opinion in the Court of Appeals and just reading the question answer aspect upon which I'm concentrating. State asked a question of Mr. Spiegel, quote, so just to be clear, it's your opinion that on the date of January 25th, the value of the tank that you received was approximately $1,330. Answer from Spiegel, yeah, unquote. If there is evidence in the record that the witness says that the tank was approximately $1,330 in value, isn't that sufficient to go to the jury and let the jury, as a question of fact, determine what the value in fact is as proven?
Your Honor, just before that interchange that you said, the state asked, Mr. Spiegel asks, the state asked for a fair market value of how much this tank was. And Mr. Spiegel says, just the tank? And the state says, no, total, everything in it. And Spiegel says, total? You're probably at 1,330 something.
Well, if that goes towards rather as inconsistent statements, or if it is an explanation of his valuation, isn't that for the jury to sort out? And if the jury sorts it out in favor of the state being a felony, value over $1,000, then isn't that the jury performing its purpose?
Well, Your Honor, I hear what the reading you're taking on that, but given I think it's very clear that he has just said, just the tank? No, total everything in it. And then says, you're probably at 1,300. It's clear that he is reiterating that evaluation for the state.
So asking it another way then, should the jury have negated any explanation that was given as a follow-up, because the state did preface the question with, quote, just to be clear, unquote? Was the jury somehow required to not take into consideration the second of the two statements, the second one being explanatory in nature, or was the jury left to perform its function as to, even taking these as inconsistent statements, which ones it chose to believe in terms of valuation?
Well, certainly, Your Honor, the resolution of an inconsistent statement or the credibility of any of the statements would be for the jury to determine. That is one full statement, though, I would contend, that he is saying, yes, this estimate includes everything in it. And that's part of that same statement. The dissent rests its reasoning more on State v. Davis, or not on State v. Davis, and contests the holding in State v. Davis, which also was supposed to have been a case following State v. Holland. In that case, the defendant was charged with taking a DVD player deck out of a car, and the deck was part of a two-part system, the other part of which was the brain, and he didn't take the brain. The evidence was that entire two-part system was worth $1,300 when new. And the Court of Appeals in that case determined that the evidence of the new value of the entire statement was sufficient to determine the value of the individual parts, even though no value for that, what the defendant actually stolen was given. In so doing, the majority holding allows the state to include the value of items not typically contemplated when you hear the words propane tank, in this case, without which the value of the item itself would have likely been insufficient to submit to the jury for a felony. This case involves a very fact-specific dissent in a fact-specific case. The dissent is asking this court to enforce its own prior holding, prohibiting speculation as to the value in this case. Mr. Wright's case, Mr. Spiegel's testimony as to value, the only evidence of value, left the jury not a discrepancy in the evidence or a question of credibility, but an unsolvable equation. X plus Y equals amount 1150, where Y could be anything from 0 to 300 when you're talking about the fuel and the tank. The state had complete control over the items listed in the indictment and the items valued by Mr. Spiegel, who offered to narrow down his estimate. And if the state had taken Mr. Spiegel up on his offer, perhaps we wouldn't be here. They had required him to break down his value for just the tank. The result was that the jury was left to speculate as to whether the value of the propane tank exceeded $1,000 as required for conviction of felony. For the reasons stated in the dissent, Mr. Wright respectfully asks that this court vacate his conviction for felony larceny and remand for entry of judgment as the misdemeanor.
Thank you, counsel. We'll hear from the appellee.
May it please the court, Honorable Chief Justice and Associate Justices of the North Carolina Supreme Court. I'm John Green with the North Carolina Department of Justice, and I represent the state in this appeal. The dissent below in this case seeks to cast doubt upon whether indirect evidence or circumstantial evidence, as it is more properly called, can defeat a motion to dismiss. This court's decisions firmly hold that circumstantial evidence with its inferences are sufficient to defeat a motion to dismiss, and the evidence here was sufficient so that the Court of Appeals properly affirmed the trial court's denial of defendant's motion to dismiss. In States versus Fritsch, and I know the justices are well familiar with this, but just to highlight it, this court held that in reviewing challenges to sufficiency of the evidence, we must view the evidence in the light most favorable to the state, giving the state the benefit of all reasonable inferences. Contradictions and discrepancies do not warrant dismissal, but are for the jury to resolve. The test for sufficiency of evidence is the same, whether the evidence is direct or circumstantial or both. Circumstantial evidence may withstand a motion to dismiss and support a conviction, even when evidence does not rule out every hypothesis of innocence. Also, when ruling on a motion to dismiss, the trial court should be concerned about whether the evidence is sufficient for jury consideration, not about the weight of the evidence. Under our law, circumstantial evidence is proper and sufficient. It's used in murder cases to send people to prison for many years or for the remainder of their life. And it's certainly sufficient in a case to decide whether or not the tank's worth more than $1,000. And we do not need to resort to algebra to solve this case. We do not need to worry about X plus Y equals 1150. Here's why. In this case, the evidence of value is sufficient to survive a very low bar of motion to dismiss because the evidence of propane tank, the value of the tank, is over 1,000 when viewed in the light most favorable to the state. And there are two pathways, at least two pathways in the evidence to reach this result. The first is short and direct, and Justice Morgan alluded to it. The second involves testimonial and circumstantial evidence. Either one of those two pathways requires sending the case to the jury. First, as noted by the dissent, Mr. Spiegel of the gas company testified 3 times about the value of the tank. The dissent compiled and quoted that testimony. It included Mr. Spiegel testifying that the tank, regulators, and gas were worth $1,330. However, on page 45 of the transcript, at the very end of the direct examination with no follow-up by defense counsel on it, the prosecutor asked Mr. Spiegel, so just to be clear, it's your opinion that on the date of January 25th, the value of the tank that you received was approximately $1,330. Mr. Spiegel answered, yeah. No mention that time of gas or regulators. That is sufficient in and of itself to send this case to the jury, period. I recognize his other testimony about valuing the tank, the regulators, the gas, and the amount thereof, and the state wants to be completely above board and clear about that. However, they at most create contradictions. Contradictions are for the 12 duly impaneled jurors of this state, the constitutional heart of our system of justice, to decide after the trial judge's jury instructions, and noting that contradictions are the fodder of lawyers' closing arguments. The contradictions in Mr. Spiegel's testimony are for the jury to resolve and not for the dissent to dissect and pick apart, and as the defendant's counsel said, fact-specific defense, or dissent, fact-specific dissent. The dissent thus usurped the constitutional role of the jury. It didn't mean to, but if you read it, it did. Also, I note that the trial court instructed the jury on felony and misdemeanor larceny. The jury heard the evidence, the instructions, and the closing arguments. It convicted the defendant of felony larceny. It could have acquitted him. It could have convicted him of misdemeanor larceny, but 12 duly qualified jurors residing in Cleveland County convicted him of felony larceny, and that verdict should stand. Now, here's the second alternative pathway. If the simple testimony and question and answer, so just to be clear, it's your opinion that on the date of January 25th, the value of the tank that you received was approximately $1,330, yeah, is not convincing because Mr. Spiegel's other statements, although we don't know, did he have an epiphany between the last time he talked about it and this one? Was he tired of testifying? Who knows what his reason was, but he answered yeah in response to that question, and that's for the jury to decide. Was he valuing the propane tank, the regulators, and the gas altogether when thinking about propane tank? In that case, that makes the dissent's discussion about the common usage fall apart, because the dissent erred by relying upon the words tank and gas and propane, and as if the witnesses could set the legal standard. What if this had been a stolen car case with a new engine, and the counsel had asked about the new engine? That wouldn't make the engine a separate part of the car for that case, and neither does it here. But in any event, he answered it, and it was for the jury, noting the other statements that he also made. Okay, so to summarize more of the, to look at the additional evidence to show that the trial court properly denied the motion to dismiss and the Court of Appeals properly affirmed that denial. All right, here's more of the evidence. The tank was discovered stolen in December 17. I'm just saying that as a background. Krott's Farm used propane to heat water to warm housing for migrant workers. Mr. Krott's provided housing to migrant farm workers mostly from June to October, and then a pruning crew came right after the first of the year. Carolina Energies installed, maintained, and filled the tanks on the Krott's farm. Both Mr. Spiegel and Mr. Krott's testified about Carolina Energies servicing the tanks. Carolina Energies obviously had a financial motive to keep the tanks full so the gas could be used and tanks refilled. The tank was stolen from a camp that was to be used for pruners coming up right after the first of the year and during the winter months, and the plumbers were there to check the heat. Mr. Krott's was winterizing the bunkhouses for those pruners. Now, while Mr. Spiegel did not know, and he said, I don't have a clue, how much gas was in the tank when it was recovered because the gauge had been spray painted, that is not the most important time. I also note that the defense counsel's cross-examination questions on page 46 about the use of the truck with the crane, which was used when the tank was recovered, the weight of the tank and how much gas was in the tank when that counsel used the words found off the farm, means that he was asking about the gas at the time recovered. However, what is key is Mr. Spiegel testified on page 39 that the last time he checked the tank, it was full. The prosecutor asked, so there was 96 gallons in this tank? Answer, that the last time I checked it, it was full. Now, the jury could infer that Mr. Spiegel meant that he had checked that tank and it was full within a relevant time of the theft because he did not add a disclaimer like, but that was months ago, or something similar. If it hadn't have been relevant, that would be something to expect a witness to do, would be to add a disclaimer. But he said the last time I checked it, it was full. Additionally, in response to defense counsel's questioning to Mr. Krott's testified, well, I had gas in the tank, the gas in the tank was mine. Now, these facts and the inferences drawn from them are important because our law includes the gas in the tank, and here's why. Not just our indictment law, but value in GS 1472A has been interpreted to mean the price which the subject of the larceny would bring in open market, its market value or reasonable selling price at the time and place of the theft, and in the condition, and mark that word, condition, in which it was when the thief commenced the act culminating in the larceny. If you're concerned about the gas, it's included in the propane tank, and the light most favorable to the state, the condition of the tank was that when last checked by Mr. Spiegel before the theft, it was full of propane fully enclosed within it. That was the condition of the tank. The tank's condition was full of propane as in the light most favorable to the state from the testimony. So even if you do not consider the regulators valued at $90 each or $180 total, I cover how they should be included in the indictment, but even if you shear them off from this case, it doesn't matter because you're left with a tank that was worth $11.50, which is the difference between $13.30 and $180. In the light most favorable to the state, there was sufficient testimonial and circumstantial evidence that the tank was full when stolen, in the Court of Appeals decision, Judges Young and Collins for the Court of Appeals properly focused on the low standard required for defeating a motion to dismiss and respected the central role of the jury, ingrained in and protected by our state's constitution, by holding whether the absence of fuel or regulators put that valuation below the $1,000 threshold was properly before the jury for resolution and did not warrant dismissal. Now note there the opening part of that sentence, whether the absence of fuel. See, the court was looking at it, an absence of fuel would take it below 1,000. And so that the fuel was part of the indictment, but the regulators, if you count those costs in, I don't think the majority was looking at the regulators as being part of the indictment, but certainly by the statement absence of the fuel it was. But in any event, my argument about the condition of the tank being full based upon the evidence and the inferences drawn from that evidence are sufficient. The Court of Appeals respected the constitutional role of the jury. Unless there are any questions, for the reasons stated in oral argument and in the state's brief, the state respectfully requests that the Supreme Court affirm the decision of the Court of Appeals. Thank you.
Thank you, counsel. Rebuttal.
Are there questions from the court? If not, for the reasons stated in the dissent, Mr. Wright respectfully asks that this court vacate his conviction for felony larceny and remand for entry of judgment as to a misdemeanor.
Thank you, counsel. Thank you to both counsel. Particularly, I want to note Ms. Reese having her second visit to the court this week. We appreciate your taking the labor and oar. That being said, Madam Clerk.
Oh yes, oh yes, oh yes, the Supreme Court of North Carolina will be in recess until 9:30 tomorrow morning. God save the state and this honorable court. Good to see you, John.
Good to see you.